Conversations That Matter is a partner program for the Centre for Dialogue at Simon Fraser University. The production of this program is made possible thanks to the support of the following and viewers like you.
Louise Mandell, welcome to Conversations That Matter.
Thank you very much. It's a pleasure to be here.
A conversation that matters a lot to me is how are we going to change the relationship between First Nations people in Canada and all those of us who came afterwards. How are we going to create access to opportunity? How are we going to ensure that people have the tools that they need to be able to realize their full potential?
Well, it's kind of, it's a beautiful place to be because after 40 years of litigation, so I'm speaking as a lawyer who has had the privilege of litigating Aboriginal and treaty rights issues for 40 years, we've actually shifted the colonial paradigm. So we're at a space where all of the Crown's denial arguments about why they don't recognize Aboriginal people's rights to the land and why, you know, they haven't recognized Indigenous people's laws and legal orders as part of our constitutional and our legal regime. All of those arguments were raised in extinguishment arguments and have now been defeated. So we've actually reached the point where the Crown governments and Indigenous governments are now able to build trust, collaborate, cooperate, and actually build systems that, you know, talk to one another in a good way. So it couldn't be a more exciting time in terms of the legal landscape that we're presently on. The law that bound the Crown when they came to Canada was British law, which was expressed in the Royal Proclamation of 1763, which required the Crown to recognize the Indigenous people's rights to land and their laws as legal rights, and then the incremental perfection of Crown title through treaty. But that didn't happen in BC. They just simply stole it. So,
can I ask you a question about that,
sure,
though?
of
And it's
course.
something that nobody has been able to settle for me. Did the British Crown realize that they needed to do that through the Royal Proclamation of 1763 because they did not trust that the doctrine of discovery would give them the legal basis to claim ownership?
Okay, so the doctrine of discovery was kind of a legal artifact that came in after the fact. The law the international law, which bound, and the British constitutional law, which bound the discovering colonial powers as the European powers moved into lands that didn't belong to them, was expressed in the Royal Proclamation of 1763. So it recognized the pre-existence of Indigenous people who lived here first, and then required the Crown to acquire the title through treaty.
Through treaty, yes.
Now, when that didn't happen in British Columbia, there became, I'm going to call it legal justifications of how the Crown stole the land fair and square. And what emerged were two legal doctrines, which I had the privilege to litigate all of my legal life, which were the doctrine of discovery, which was based on the false supremacy of the Crown governments, and the doctrine of terra nullius, which was based on the false inferiority of Indigenous governments, basically being peoples without laws. And so the fiction emerged that the Crown brought law, the law came when the Crown governments came, that Indigenous people needed to be civilized because there was some Darwinian scale of civilization with Crown governments and the legal thinking and the cultural thinking of the West being so much better, and Indigenous people would just see the rightness of all of this progression and enjoy the benefits of assimilation. And this legal construct actually morphed itself into legal doctrines, which I litigated in the context of all the extinguishment arguments that really began in Calder. Like your question was, was Chilcotin the straw that broke the camel's back? But actually, I think...
Well, no, I'm asking, did it put us over the top? I know that if we roll it back through Delgamuukw and Sparrow and Calder, that we see the progression of that.
Yeah.
But,
well, it depends what you mean by roll us over the top. Like, I would say that if I were to be standing at the top and see where we are now, where we really are is in a landscape of legal pluralism, where we've got two legal orders, two sets of laws, two worldviews, both with titles, both with jurisdictions. And the question now is how to make find mechanisms so these two legal orders can make decisions about the land together and properly make decisions about the people. It's not about one legal order borrowing from the other or making space for the other. It's actually two legal orders on the ground right now. Now that framework, that legal pluralistic framework was achieved with Delgamuukw. What Chilcotin did was it ended the last of the Crown's extinguishment arguments. They reinvented another extinguishment argument post Delgamuukw and said, well, you've never proved it, you haven't gone back to court, you've got to prove your title for us to recognize it, which we attacked in Haida. In the Haida case, the Crown said that we don't need to consult and accommodate, we don't need to do anything until they prove title. The court said no. Upon the assertion of Crown sovereignty, there's constraints on the Crown's jurisdiction, including the duties of consultation and accommodation. So then the Crown reinvented denial again and said, well, you've only got title over the areas that you can prove, and they identified it as small spots on the landscape. And that last legal attempt at trying to defend their denial of title and jurisdiction all these years, that last defense was defeated in Chilcotin. And so you might say that the Chilcotin have proved title to a fair amount of a large segment, not small spots, but territorial.
Right, not the postage stamps, but from mountaintop to mountaintop.
And the Crown hasn't proved anything. We still haven't had the Crown justify how it's achieved the title and jurisdiction that it's asserted. So that's the place that we're presently. And it's a legal landscape which is actually beautiful because it involves everybody, businesses, it involves us, it involves the kids at school, it involves companies, it involves governments, it involves Indigenous people. Everybody now needs to recalibrate into allowing for and understanding what Indigenous laws and legal orders have to offer, and how are we going to live, build trust, collaborate, live together, work together, and actually steward the land together.
Got to get you to hang on for just a second while we take a quick commercial break.
Okay.
We'll be right back.
Conversations That Matter is a not-for-profit program made possible thanks to the charitable support of the following and from viewers like you. Please visit conversationsthatmatter.tv and help us to continue to produce this program.
So, in the midst of all of this, separate from it, but at the same time, the federal government comes out, apologizes for the Residential School Act.
Right.
The Truth and Reconciliation Commission does its work and issues its report.
Right.
The question now is, so with all these pieces now starting to come into place, how do we develop the mechanisms that allow us to truly reconcile with one another and live together?
First of all, I like to go back to the Truth and Reconciliation Commission, because those 94 recommendations, every single person in this country can find themselves in it. There's every walk of life. It's like you make change one breath at a time, one step at a time, one day at a time. You just keep moving forward. And for the most part, I think that the underlying premise of the Truth and Reconciliation Commission is that if you're a plumber, you can do this. If you're a teacher, you can do that. If you're a lawyer, you can do that. If you're government, you have to do that. But mostly it's also about listening. Like we really don't know all what we need to know about where we are together, who we are together, and what the tragedy of colonization is that it stereotyped Indigenous people as basically being savage or without laws. This is in the legal context, but also a lot of cultural stereotypes which allowed us culturally to subtract Indigenous people from our circle of compassion, so they weren't quite as human as the rest of us, and we could do things in the interests of making them more so. And so now the absolute the imperative that I think the TRC was so beautiful at doing was saying we all really need to stop now and get to know one another. We need to listen to one another. Like, you actually have to listen to where Indigenous people are in their communities, in their nations, in their aspirations, in their dysfunctions because of what's happened to them. And we've got to approach this from that as our starting spot. Our starting spot being to listen, learn, trust, cooperate, and then learn how to move together in helping one another into the future.
So how do we then start to develop the language that when we're talking about the environment, we're talking about the same thing?
Right.
And in a way that we can actually hear one another. Because if this is such an important component, it's almost as though we have to peel back the layers of communication to identify exactly what it is that we're talking about.
So that's such a good question. So one of the, I'm an Indigenous lawyer. I've practiced Aboriginal law for close to 40 years, and I have only just begun to understand Indigenous laws. Like I thought
After 40 years.
Because I was so involved with Aboriginal law, which is the inner social law between the Crown and Aboriginal people, and how the Crown should behave and how we're going to live in a framework or a constitutional framework of rights and how we're asserting rights. And in that particular paradigm, I didn't really understand the strength and the power of Indigenous laws. And it was only when first of all, the court opened the space and said that Indigenous laws pre-existed and survived the assertion of Crown sovereignty. They haven't been extinguished. They find expression in the Constitution. The jurisdiction isn't exhaustively divided between Crown governments. There's jurisdiction in the Indigenous governments. I started to pay attention, well, what is this Indigenous law that I'm listening to? And what I'm coming around to answering your question, because what I heard when I started to really listen to what Indigenous laws were about were these ancient stories which arose from the land, which carried these fundamental principles of respect and reciprocity and balance and humility, and all of these principles which were embodied in stories, which were applied to present situations, which allowed people to live in peace and harmony, not based on a them and an us, but based on us all being dynamically connected and interconnected in a fundamentally dynamic way. So it doesn't mean that I have to be like you. It means that you and I are both going to exist in our differences, and the unity will be that we find a way to be harmonious together, not so much that we agree, but that we're both entitled to live, and by standing you up, I stand myself up. We're all one. And I kind of got a sense of this by paying attention to the world, to the lens through which Indigenous laws govern the behavior of Indigenous people, which I actually think it's really remarkable to me that Indigenous laws survive colonization. It's remarkable to me that anything survived colonization. Like, unlike the Holocaust, which was an event and it's over, like, we don't have a space between yet. We're still in a colonized mentality. We have all got to move beyond it, and the governments are still in colonizing behavior, legislation, litigation, government negotiation mandates, government litigation mandates. All of this is still framed within colonial mentality. We haven't actually got to the point where we've given space for all of us to receive the benefit and beauty that Indigenous law offers. So you come back around to the land and you say, so, what do we do? Well, one of the pieces that I think personally we can do is go back to the land, all of us, and start to pay more attention to the way the energy of the world, the land feels through us, to take better care of the land just in our personal lives, and then to be open to this extraordinarily rich tradition which somehow survived colonization, which is available to us as a legal tradition in this country, which is now required to be taken into account when the government makes decisions about how the land will be used, which we can educate our kids about, and which can, help the survival of 7 generations of all of our cultures. all of this is available to us now. So I do think that it's a matter of just opening the beautiful box and starting to listen and educate around and, take responsibility ourselves for, sharing that worldview, even if it's just a moment a day, every day, and seeing what it is that comes from that.
This is our second break.
Yeah.
We'll be back in a moment.
Conversations That Matter is a not-for-profit program made possible thanks to the charitable support of the following and from viewers like you. Please visit conversationsthatmatter.tv and help us to continue to produce this program.
When I think about the amount of patience that First Nations have had in this process, I get the sense that they're still going to have patience, because there's so much of the rest of Canadian society that is even unaware of the changes that are happening. How important is it, though, to the country as a whole that we don't let this fledgling beginning falter? Because if it does, I think that it will be a scar on the Canadian psyche for generations, maybe another 100 years or more. Is it important to us that we collectively get behind this and help to make the changes that are necessary?
Well, it's actually mandated now by law. Like, it's not a matter of personal choice. Like, when you say patience, there was a lot of patience when the status quo was not only broken, but it was illegal.
Yeah.
Like, we were living in a paradigm where the rule of law didn't apply to Indigenous people. The law required the Crown recognize their rights to the land and laws as legal rights, and that didn't happen. So we've lived in a paradigm where the rule of law didn't apply, and now that is now no longer capable of, that won't happen anymore in that sense. So when you say Indigenous people had patience, I mean, I would say more like perseverance. Like, I worked for the Union of BC Indian Chiefs for 40 years, and the patience that people had was all about keeping the struggle alive. It was all about moving along with it. It wasn't about, just sitting back and allowing for whatever was happening to take place. It was a very proactive education that I was a part of, and a struggle to make justice align in the Canadian society. So when you ask, we can't, how do we move? Perhaps the best way is to start with this beautiful dialogue, because you're just really inviting something different to happen in the next moment. You're inviting some new insight to arise, which will help shift somebody's behavior, which will help somebody be more open to hearing what is a step that they can take in their lives for better or for worse. It's like a lot of people feel they can't take the step because we're changing a narrative, and that's really what we're doing. We can't change the past, but we're changing the future by the story we're telling. And
we have to.
We have to. And a lot of people think that if they don't hold on to this old narrative in some form, well, they're worried about, all the benefits that they've reaped from the old narrative's story. They worry that something's going to get taken away from them. But this isn't a narrative about taking something away from them. It's a narrative about us using our collective abilities to work together to embrace a tradition which has survived on this land a lot longer than capitalism, and which gives us the opportunity for that kind of survival if we can possibly do it. Like, we're not in a position where we've got a lot of humans don't have a lot of time.
Last break, and then we'll get back to be able to finish off this conversation. We'll be right back.
Conversations That Matter is a not-for-profit program made possible thanks to the charitable support of the following and from viewers like you. Please visit conversationsthatmatter.tv and help us to continue to produce this program.
Well, it's not First Nations that are holding it back. Even though there may be a whole host of issues within First Nations communities, it's the rest of Canada. I look at even our current government, whom I applaud for at least starting to address this. Out comes the United Nations Declaration on Indigenous Rights, and they say, we're going to accept it, and then they go, well, maybe not so fast. And is that the process that we're going to be going through? 2 steps forward, 1 step back, 2 steps forward, 1 step back. And are we going to have to work our way through those, incremental changes for a while longer?
Well, I'm not quite sure exactly whether the process is 2 steps forward, 1 step back. I think what's happening right now with this government and implementing the UN Declaration is that one of the most fundamental aspects of the UN Declaration is, at least in terms of how the land's going to be used and taken care of, is the right of free, prior, and informed. Actually, it's the imperative of free, prior, and informed consent. It's actually really just all about what I said earlier: 2 legal orders. You've got to listen to one another. You've got to find a harmonious way to interact. 2 sets of laws. Of course, consent is the respectful way for this to happen. We've got to find mechanisms to make it happen. We don't have them yet. The Treaty Commission is not it. We haven't achieved that mechanism yet because we haven't been in a recognition-based relationship. We've been in still a dominant relationship with Crown governments. The doctrine of discovery still, lives on the ground. So we do have some steps to take, which we might not know exactly what the right ones are, but we have to start taking steps forward. And I can see that, we'll make mistakes in the sense that some things will work better than others, and we've got to start shifting ground. But I don't mean mistakes in some kind of chronic way. I mean just as we all learn together, you're going to do things that are more skillful and in some cases less skillful. And I think that's where we are right now. We're in a stage where we've got to be building these mechanisms so that these 2 legal orders can talk together in a good and respectful way. And what is the business of Indigenous jurisdiction shall be moved over to that jurisdictional body to deal with, and what the Crown does better or needs to continue to do in its other way, then we've got to find ways for jurisdictional relationships and the jurisdictional interplay. And we don't know exactly which way to go, but we've got to keep making process.
But intent has to be at the core.
I like that word. I think intention is the whole of it.
And if we intend to get there, together we can.
Yes, I really agree with that. I think if we intend to listen to each other, we intend to allow for the space that Indigenous laws and legal orders need to take, we intend to help Indigenous people with capacity to heal from colonization in their own way, if we intend that we're both going to be making decisions about the land, if we intend that Indigenous people are going to be self-determining in ways that we are self-determining as a culture, and we intend this for our children, we are so going to get there.
It's my belief that if we get there, then Canada has the ability to realize its full potential when all of us get to participate in whatever that's going to be.
I agree, and I just wanted to say, though, that I am very non-future oriented in this sense, that I really think that what we're doing today is reconciliation. Like how people handle their day to day, that's getting there. Like it's not some destination, it's how we are right now with each other in the ways that we each can do within our own circles. How can we move this along? That is there.
Well, I applaud you for all the work that you've done to help move us to where we are today. Thank you ever so much for coming in and having this conversation.
It's been such a pleasure. Thank you very much.